I am Mindy McCloughan, President and CEO of Loveland Chamber of Commerce, and I get the distinct pleasure of moderating the labor panel. And I liken our current labor challenges into birthing a baby without an epidural. And let me just tell you, for those of you men in the room who have no absolutely idea what I'm talking about, it just means it's real damn painful. Because we all know the challenges our employers, small, medium, and large, are facing in securing and retaining the workforce they need to propel our business forward. Larimer County's 2.6 unemployment rate outpaces Colorado's 3.6 rate, whereas Greeley's 3.7% aligns with the national rate, but slightly slower than state rate. These remarkable numbers are a far cry from where we were a mere 2 years ago. Compounding the challenge are policies and regulations that are increasing the cost to do business and to hire quality employees in an environment of unprecedented inflationary pressures in which Colorado also surpasses the national inflationary rate. The last 4 years have seen a myriad of policy and regulations affecting workforce or workplace, the employer-employee relationship, and the overall business climate. Meanwhile, there's an increasing momentum for labor unions nationally, and Colorado is a growing factor in business that must contemplate. We've worked with our partner business organizations across the state to successfully fend off problematic policy measures that would have upended the necessary balance between employer and employee. For the Power Act to early iterations of the family law and E-TRIP, however, the trifecta environment greatly affected our ability to interrupt passage of several measures and the resulting regulations. Today, we're so pleased to be joined by two individuals who bring unique perspectives to the labor workplace issues that we've encountered and how the current new political landscape will affect future deliberations on issues related to labor, workforce, and employer-employee relations. Joining us today is Mike Bell of Ogletree Deakins. Mike represents employers in all aspects of labor and employment law, focusing his practice on the defense of discrimination, harassment, and retaliation claims, employment-related torts, and civil rights claims under state and federal law. He is also one of the firm's foremost experts in reductions in force, pay equity, and USERA compliance. Thank you for joining us today, Mike Bell.
Thank you.
Also joining us for this discussion is Phil Hayes with Populi Public Affairs. Phil is the Chief Contract Lobbyist for the Denver Pipefitters Local 208, a labor union, whom we find ourselves aligned on key issues from transportation, infrastructure, and overall business climate and health-related matters. Each will bring a slightly different perspective and information to our conversation this morning. Michael will share a look at the current legal landscape for employers given recently passed laws and regulations. And Phil will provide a look under the cover to share some of his insights in the labor agenda and what might be in store for labor and employers as we enter the upcoming session. So Mike, we welcome your insights on policies like family, POWR, and the general employer environment today.
Absolutely, I appreciate it. Well, the last, especially 2 to 3 years as a management side employment lawyer in Colorado has meant job security for me. I have had an extremely busy few years practicing in what the rest of my firm has taken to calling California East. And that really kind of describes the current labor and employment landscape in the state. We have really, in the course of just a few years here, I think, transformed into one of, from an employment law perspective, the most employee-friendly states in the union, if not number one. I think that we're pretty much nipping at California's heels right now in that regard with respect to pay transparency, with respect to HFWA, paid sick leave, with respect to family, potentially with respect to the Power Act, if that ever comes to pass, as well as numerous other issues, including non-competes, new non-compete legislation. I think that this all sort of started from our perspective, or my phone really started ringing off the hook with the HFWA's passage and that paid sick leave regime, which has not only the feature of paid sick leave, but also the supplement that still persists for COVID-related issues and which has recently been expanded to essentially anything going on with your lungs. It sounds like it's now going to be covered under that supplement, that additional 80-hour supplement. And kind of what's been a little frustrating in that is not only has that been a challenge for employers to comply with, but it has also been constantly interpreted in slightly different ways by the Colorado Department of Labor and Employment through their numerous informational bulletins that they put out, interpreting what they believe those regulations to mean and what the employer's obligations to be. And that's been very difficult to keep on top of. And then of course, family, I think, is going to add another layer on top of that, because once that comes to pass, obviously the premiums for family are going to be started to be deducted next year. 2024 is where we're going to see those entitlements actually start to take place. And so in that regime, in 2024, we could very well see a situation where a typical employee could have available to them up to 4.5 to 5 months of job protected paid leave. And that is a daunting prospect for a lot of employers, but one that nevertheless has to be prepared to be complied with. I think also the non-compete legislation that was passed this year was one that really I got a ton of questions about, largely because it flew under the radar in many respects. There was no press conference, there was no public announcement of that, but what it did was essentially gut the potential to enforce any sort of non-compete in the state outside of a few really narrow circumstances with respect to very highly compensated individuals and individuals that are exposed to trade secrets of a particularly sensitive nature, such that a non-compete is going to be a reasonable method to enforce and protect them. So we haven't seen those that come to fruition yet in terms of litigation, because it only applies to non-competes entered into on or after August 10th of this year, but that's going to happen. And we're going to be interested to see how the courts interpret that, and what was already kind of an increasingly difficult venue to enforce non-competes and protect trade secrets in the state. I think it's going to get more and more difficult. And then, of course, the largest issue that I've had, and I think that a lot of employers have been dealing with, really regardless of the size of their presence in Colorado, has been pay transparency. That has been, I've probably given, I'd say 7 speeches on that topic, and every single one I get through about 10 minutes of the speech and hands free, and I spend the rest of the speech answering questions, because it's an extremely difficult regime to comply with. It seems to be consistently evolving in how the agency is interpreting those regulations, and honestly, I think that it's really impacted some of my clients' decision to either expand or to have a presence in these states. Because merely having Colorado employees, even if you have one, subjects you to the requirements of that statute, one of the most onerous of which is that you have to notify all your Colorado employees of all promotional opportunities, no matter where they are in the world, before that promotion happens. And that is a daunting prospect, especially for a lot of companies that have perhaps a modest Colorado presence, but a very large extra Colorado presence. So that interpretation, as well as the interpretation of the agency that with respect to the level of pay transparency they want to see in job postings, they're going to apply that not only to jobs that are definitely here in Colorado, but also jobs that are quote-unquote remote jobs that could be performed in Colorado, which frankly is an interpretation that is directly contrary to the language of the rule. The rule specifically speaks to jobs that are to be performed here, not just jobs that hypothetically can be performed here, but nevertheless, that's been the agency's interpretation, and that's what a lot of my clients have had to struggle to comply with in getting their job postings, and salary ranges, and descriptions of benefits that are required of those postings in effect. So, those and all those things really are things that have happened since COVID, and things that have sort of, I think, perhaps not gotten as much publicity in the general public because of the pandemic, but certainly among my clients and among employment buyers, they've sort of made this state one of the most challenging states, I think, for employment law compliance around the country.
Thank you, Mike. Phil, tell us about the Pipefitters legislative agenda, what your colleagues in labor might be pursuing, and your read of the current legislative and political landscape.
Sure. Good morning, everybody. Thank you for having me. My name is Phil Hayes. Appreciate the introduction and the opportunity to address you this morning. One of the interesting things about me is, before I began my lobbying practice 8 years ago, I actually served 8 years prior to that as the legislative and political director for the Colorado AFL-CIO. And even though that may scare some of you, one of the interesting things about me now is I actually not only represent 4 of the largest trade unions in Colorado, but I'm also the principal lobbyist for Target Stores, Raytheon Technologies, and I'm on the lobbying team with Civitas Resources. So I kind of straddle some very unique perspectives in this discussion, and certainly am accustomed to representing both business and labor in the state of Colorado, and understand the implications and the concerns and challenges and opportunities that sit therein. I won't repeat a lot of the issues that were flagged by Mike. I think, with the majorities that the Democrats now hold, the Democratic Party now holds in the Capitol, we're going to see a lot more of the same type of policies. We're going to see, issues around workers' comp this session. Don't know a lot of details yet, but I understand there's a bill coming on workers' comp reform. We're going to probably, have people looking at equal pay. We're going to have people looking at, the implementation regulations around things like family and the paid sick leave and the things that you guys are concerned about and monitoring. I think in terms of the numbers that were kind of mentioned in the last panel, and I kind of chuckle at this because it's just really astounding. I mean, I can actually, as a labor lobbyist, run a bill and lose 12 Democrats in the House and 4 Democrats in the Senate and still pass my bill. Now, does that mean that I'm, advising my clients to go out and concoct policies that will be so controversial that they will lose 13 or 12 votes in the House and 4 votes in the Senate? No. We approach our work very strategically. We try to work with our contractors and our other business allies to come up with policies that are reasonable. I think that one of the things I would tell you about working with labor unions, whether it's trades unions or service unions or industrial unions, we are all creatures of compromise. The fundamental basis of our existence is collective bargaining, which is, the key word is bargaining. We want to drive a bargain that benefits workers and creates a fair compromise for good wage benefits and work rules that give our members the ability to live successful lives and retire with dignity and earn a good living and support the communities where they live. Treating us as partners and understanding that fundamental basis for our existence and bargaining is a good approach to working with us in this environment at the Capitol. I think if you come with us with ideological, conflict, we probably won't respond well to that. If you come with us with, real concerns that you can demonstrate are problematic and that we really need to sit down and work with you on, I think you're going to be surprised at how labor organizations are willing to actually try to unpack that and come up with reasonable policy. In terms of our agenda for the building trades, and I represent electricians, plumbers, pipefitters, and utility workers in Colorado. I think there are really 2 key areas of focus for us in the upcoming session. I think the first is really workforce development. My clients, working with a bunch of the different contracting associations and Colorado State University, which is here in Northern Colorado, obviously, did a study in 2017 and then updated it again in 2020. When you look at the needs in the construction industry right now, we need about 20,000 skilled trade people in the next decade in Colorado in order to meet the needs of the state. We are a state that is starving for infrastructure upgrades and maintenance. Luckily, some of the federal resources that are coming down are really doing a lot to get us caught up. But we are not proactive yet. We're not in a place where we can look ahead. We're doing a lot of the deferred maintenance, a lot of the projects that sat dormant because we didn't have the resources at the state level, and we don't have the workforce to compete and to get all those projects done. And I think it's a scary proposition, whether it's transportation, whether it's energy, whether it's capital construction. If we don't really aggressively attack the workforce development agenda in the construction trades, we're going to basically be resigning ourselves to importing labor from places like Texas, California, large population states that don't have necessarily the same values and don't necessarily support the tax base locally as hiring companies and workers that live in Colorado. And so that is a huge process for us. I think the thing that you need to understand about unions in the construction trades is we are organizations whose history dates all the way back to the Middle Ages. Construction guilds, trade guilds, back in the Dark Ages where if you were a barrel maker, you belonged to the barrel making guild. If you were a carpenter, you belonged to the carpenter guild. These training processes that we go through with apprenticeship programs that are registered with the U.S. Department of Labor and that have legitimate bona fide curriculum, teach towards industry standard certificates and professional licenses, provide real pathways toward a scheduled and terminal point of exit out of the training program and into the workforce, and then have approved bona fide curriculum. That is the gold standard in terms of our perspective. Certainly, there are other ways to train construction workers, but one of the key things that business leaders should understand about apprenticeships, if you don't have a job for that individual, then we can't put them in the apprenticeship training. So, a lot of the work that we're going to be focusing on, and we've been focusing on, is working with our contracting associations, working with state, local, and county governments to educate them on the value of when they build something, and certainly private business too. When you build something, hire a contractor that is actually training people in a bona fide apprenticeship program, whether it's union or non-union program. Because what that does is that provides the job that apprentice can actually then get that critical on-the-job training for for the experience they need to attain their professional credential or license. I think the other thing that I would mention, and this was briefly mentioned in the previous panel, there's so much happening in the environmental space in Colorado right now. For the building and construction trades and the utility workforce, there are both huge risks and huge opportunities. One of the challenges I think that we hear in the political space is this great rhetoric about green jobs being created by all these initiatives. I will tell you that's not always true. What we've seen, based on the Department of Labor statistics data, the average solar installer, for example, in Colorado makes about $45,000 a year with, I would say probably substandard benefits. They have health care, they might have a 401k, but it's nothing in comparison to the six-figure salary that a worker at a coal or gas-fired generation plant makes, along with their full family health coverage and their pension. Now, things change in the market. Benefit packages change, evolve, whatever. But I think we have a grave concern about if we're taking jobs offline in a community like Craig, Colorado. There's 300 people that make six figures. That's not in northern Colorado, but you will have some impacts here in this part of the state. And you're removing several hundred jobs that make six figures from that community. That is devastating for that economy. And so how do we make sure that we have a transition towards clean energy, whether it be renewables or alternative clean energy like geothermal, nuclear, whatever, that sustain the level of economic stability for our communities. And so I think there's a lot of work that we can do together in the labor and business community on those fronts. But like the previous panel said, there's going to be a lot of bills coming forward. I think the leadership is, I think, earnest in their belief that maybe we should take a deep breath and let some of the things that have implemented or passed in the recent years implement. But I can tell you there's going to be a couple bills that you can expect to see. Building performance standards, 2021 bill that required there to be a task force to recommend how we get our buildings more efficient. Many building owners in this room probably know that there's state requirements that you benchmark your building efficiency. There is going to be new rulemaking coming up by June 1st, 2023 that will take the recommendations of a task force that's been working on these issues and implement those into regulation. You will likely, at your own expense, have to figure out a way, if you own a building, to get your heating and hot water 80% electric by a date certain. If you don't comply, you can certainly, I think, under the law, apply for exemptions and extensions. But once you get that point of compliance, you will have a $5,000 per incident fine. And so, there's going to be a lot of work that's going to come out of that, opportunities for construction industry, jobs, but there's going to be a lot of expense on the part of business owners, and I think we need to be working together on that issue. There was a 2021 bill that called for an environmental justice task force that really was put together to give recommendations back to the state for further legislative action on how communities that have been traditionally disproportionately affected by pollution and greenhouse gas emissions can have a voice and a say in how we move forward with our development of businesses, manufacturing, energy. And there was an 18-month process. They made recommendations back to the legislature. And I think it's a balancing act, like the previous panel spoke about. We want to make sure that the communities that have been negatively impacted have a voice in this process. But we also want to make sure there's not an actual veto power for citizens to stop development when it's necessary, or to prevent businesses from operating effectively. I think one of the things that we're hearing about that we'll be engaged in is an ozone bill. There's not a lot of details yet about what is going to be in that, whether it's going to be targeted to a specific industry like oil and gas. But ultimately on the Front Range here, we have an air quality problem, a major one. We can't put our head in the sand, but we have to come up with policy that ultimately allows businesses and commuters and consumers and everyone to function properly, and that is certainly something that we're going to be watching carefully. I think the final thing I would mention is, which will certainly I think probably be the top priority for my clients in this space. In 2010, we passed a law called the Best Value Employment Metrics statute. And what that did is required the Public Utilities Commission, when they consider energy resource acquisition, pollution controls, certificates of necessity, other procedures where the commission is the deciding determinant about whether those projects move forward with the unified rate base or fees collected through utility bills. We required a law that said you have to evaluate, are you paying people good wages? Are you paying proper benefits and health care and other things that sustain a workforce in this space? Are you providing real training opportunities? Are you hiring businesses and employing workers that are from Colorado? We didn't mandate these things. We said, PUC, you have to consider them as you approve these projects. And there was an audit that came out in August this year, and it's insulting and horrific. It said of the 90 bids and the 90 projects that were bid under this statute, 85 of them didn't mention the metrics at all. And 47 of the bids had literally not one mention by the bidders on how they would execute these metrics in the execution and construction of the project. I'll leave you with an example of why that's a problem before we move on to the next Q&A. A major utility in Colorado built one of the world's largest wind farms in eastern Colorado. Some of you probably, if you've driven towards Kansas, have gone past all the windmills. The utility ended up hiring a national contractor, which happens a lot in the utility space. And they submitted they did submit their metrics, which is good, but they basically told us they were going to hire 80% of the workforce out of Colorado, and that of the 20% they were going to hire, it was going to be some of the lower wage jobs. That helps none of us, ladies and gentlemen, when we're using our collective resources that you, your neighbors, your employees pay and their utility rates to build a major power generation installation, and we're going to have 80% of the workforce coming from out of state. That's something that we're going to be very focused on in this next coming session, is making sure that those metrics are being complied with, and that the PUC cuts their poor performance out and does what they're supposed to do on a law that's now been in place for 12 years. But I'll pause there and
okay, thank you.
Go to questions.
Thank you, Phil. Mike, this question is for you. How has the recent policy shifts affected the rapport between employers and employees? Has it created more tension, alleviated tension, or is it dependent upon the specific policy?
I think it depends a little bit. I think overall we've seen some increased tension for a number of reasons. For example, I think some of the new laws, especially the HFWA and the paid sick leave requirements, have stripped a lot of the ability of some employers to be flexible in their paid leave provisions. I have one client who had really quite generous PTO policies prior to the passage of the HFWA, And at the end of each year, it's a mining facility, and they honestly didn't have that many folks take vacations. Very hardworking workforce, and kind of the preferred method was work hard all year and get paid out your very generous PTO balance that you didn't use for the end of that year. Well, in trying to comply with HFWA, and they wanted to do that through this global PTO policy, they can no longer do that payout, at least as to 48 hours. 48 hours of that has to roll over into the next year. And so even though that's they're complying with the law that was passed, and that law was ostensibly passed to provide protections for the workers, that ticked off a lot of their workforce. And that was not a popular measure, and it took some difficult messaging in order for them to explain why that change was being made, and it wasn't any sort of punitive change, at least on their part. It was just trying to comply with the law. So I think that's been a bit of a challenge. As I mentioned, the pay transparency regulations have been some of the more challenging, though, with respect to, I think, just a matter of it's so complex and confusing that many employees don't understand exactly what the requirements are. Some believe that the Colorado law entitles them to know what all of their coworkers are making. It does not. Some of them believe that they're entitled to more disclosure than they're actually entitled to. And then some employers, we saw this especially early on with the passage, there was, and I got this question a lot. I said, well, here's our proposed strategy for complying with this, especially when the new guidance came out about remote jobs. Okay, we're just going to say that this is our posting. It's going to go out, and it's going to very clearly say Coloradans need not apply. We're not going to make this open to Coloradans, and therefore we don't have to comply with the Colorado statute. And that obviously created a major blowback publicly. There were actually a few public shaming websites that sprung up. One of them I think is still up. It's called ColoradoExcluded.com, and you can go on there and see these companies that have done that or tried that as a strategy. Then the CDLE cracked down on that and said, no, you can't do that. We're going to deem that to be a violation of the rules, despite the fact that, from a certain perspective, even though that might not have been the most employee relations friendly way to try to comply or not comply with the statute, at the end of the day, companies should be entitled to decide where they're going to hire employees. And I think that interpretation was very difficult to comply with from an employer perspective, but also created this concept, or maybe the messaging to employees that, okay, they're just trying to find a way to get around this statute, when in fact, what was being attempted, at least in some of those companies' respects, is we're trying to get around not so much the statute, but this interpretation that the CDLE has put out that would essentially require us to include pay disclosures in jobs that we never really thought would be performed in Colorado. We're just trying to, especially in the context of the pandemic, make those jobs remote jobs, give some flexibility, try to find more people in a very tight labor market to occupy those. But as soon as you tag that job with a remote label that it could possibly be performed in Colorado, that means you've got to have the salary ranges in there, and you've got to have the other information in there that's required under the statute. So I think those are a couple of areas where I think we have seen some increased employee tension.
Well, real quickly, while you still have the mic, are there modifications or two to current policies that the NCLA might seek to improve upon or better balance the effect of the current policies on employees?
Well, I think that, I think that remote, again, the remote interpretation of the current equal pay transparency rules is just that. It's an interpretation, and it's one that has proven quite difficult to comply with, and it's one that I think could be improved upon via amendment to the Equal Pay for Equal Work Act, and essentially correct what I think has been an incorrect interpretation of that piece of the regulation by the agency. So I think that's definitely one area that we can look at.
Thank you. Phil, you touched on this briefly, but how does the current makeup of the state legislature affect the determination of the policies you or your labor colleagues choose to pursue?
No, thank you for the question. Yeah, I mentioned this in my intro. I think the reality is that labor unions are looking at the majorities, in the chambers, And as I said earlier, I mean, I can lose 12 votes as a labor lobbyist in the House, and I can lose 4 in the Senate. We've never had that, opportunity before. But I do think you're going to not see people, from labor overreach. I mean, we've had Democratic majorities for years. We've had 3 governors in a row, and nothing is ever easy for us. Unlike some folks in the environmental community who seem to get everything they want sometimes, in my opinion, we really struggle sometimes, even with Democrats, to fully realize the potential of the policies that we pursue. So I think you're going to see strategic and thoughtful engagement on the policies that we advance, at least from the clients that I represent. And I think, like I said before, I think engage with labor as collaborators and bargainers. I mean, collective bargaining is the operative word is bargaining. Bring them your challenges, your concerns, and treat them with respect, and try to forge compromise that is reasonable. And I think you'll find success.
Well, with that, where do you see the potential for a difference of opinion between your organization and other labor organizations like the AFL-CIO or Colorado Wins?
Yeah, thanks for that. I think what folks in the business arena need to understand is the AFL-CIO is essentially the Chamber of Commerce for labor unions. And it operates very much like your chambers do. And ultimately, the individual unions like the ones I represent, I mean, we really focus on industry-specific and sector-specific priorities. All of us are in the labor movement are in broad agreement about worker protections, safety, benefits, healthcare, all the things that, wages. And you're not going to find a lot of differences amongst union organizations on those issues. I think the one place where rarely we might have quarrels is if we cross streams into each other's industry sectors. Environmental policy, for example, is a place where we've had some challenges where unions that have social justice agendas around climate change, but their members aren't impacted by the actual policy outcomes that are being debated, engage, they support a bill that we oppose, or vice versa. And we say, hey guys, this actually costs our members jobs or threatens their jobs. Why would you, support something that will hurt our members? That is one place where, there is some challenging politics internally to the labor movement. But I would say 99% of the time, labor unions are on the same page and try to be supportive of each other, as well as, we want our employers to succeed too. I mean, we work very closely with our employers, probably more closely than some unions, but there's nothing special in a trade union's DNA that makes us different than any other labor organization. We just actually sit down with our employers probably more effectively and cooperate and collaborate on business and economic development with them.
Thank you, Phil. Mike, this one's for you. Where do you see the greatest threat to employers in the upcoming legislative session?
Power, for sure. The power bill, I think, is one of the most dangerous bills that we've seen come across in quite some time from a defense employment lawyer's perspective. As many of you know, the general harassment standard that has been in place for years and years is embodied in Title VII of the Civil Rights Act. And that has been a standard that's evolved through decades of case law, jurisprudence with respect to what exactly constitutes harassment that is actionable in the workplace. And that has evolved into a standard that is really common coast to coast, and that's the severe or pervasive standard, that the type of harassment that is actionable in the workplace is either harassment that is severe, so you might have one particular instance of a sexual touching or something like that, that even though it was only one time, it was extremely severe, so that's actionable, or pervasive. Not as severe, perhaps, but something that is going on constantly, a constant stream of jokes, slurs, epithets, come-ons, things like that, depending on the nature of it, that could also be actionable. And from an initial perspective, one of the things that concerned us about the initial rhetoric that we saw by the proponents of the power bill is a fundamental misunderstanding of that standard. We heard time and time again that a couple of those proponents of that bill legitimately believe that the standard was severe and pervasive, that it has to be both, and it's just wrong. That's not the case, and it hasn't been the case for years, hasn't been the case in Colorado, hasn't been the case anywhere. What I think that they are concerned about is the fact that there has been this large body of law built up that as employment defense lawyers we can point to, and there are, pretty much any situation, even though harassment cases they can be difficult to defend and difficult to analyze, but almost always I can find some case out there that deals with something quite close to what we're looking at. And I can be able to say, hopefully it's a case that went in our favor, and I can, as a defense lawyer, say, okay, here's what they're alleging. Here is another case that we have in another federal court case that we looked at the exact same thing, and the court decided that even in a slightly more egregious situation, that did not rise to the level of severe or pervasive. So that afforded us, and has afforded defense lawyers representing employers, ways to defend against those types of claims and be able to either get dismissals or summary judgments on claims that, even though somebody may have experienced an offense in the workplace, it wasn't the type of offense that rises to the level of sex discrimination or sex harassment or discrimination on the basis of whatever other category is covered under Title VII, race, religion, et cetera. But what this bill would do is essentially change that standard to the definition of harassment being anything that is offensive to a reasonable person. And that would do a couple of things. Number one, it would present a massive burden on HR folks and managers trying to investigate those types of claims, because essentially any sort of workplace slight, any sort of off-color joke that was overheard could on its own, not as a building block, but on its own, constitute an actionable basis to bring a lawsuit, to bring a charge and to bring a lawsuit. That's going to greatly multiply internal work. And then the other thing it's going to do, I think, is, as of right now, I would say 85% of my practice is in federal court, because the standard under Colorado state law and federal law is essentially the same. There's not a massive benefit for a typical plaintiff's lawyer to bring a case in Colorado state court. If this passes, that's going to change massively. I would say that may flip-flop. I may have most of my cases, at least harassment cases, in state court. And state court is a much more dangerous venue for most employers. You don't have nearly, for one thing, federal judges have robust clerkship benches that they have, who are some of the best and brightest law students in the country, who are assisting them in analyzing these issues. There's this massive line of jurisprudence and case law that we can pull from and be able to analyze those issues. And essentially this would hit the reset button on that and kick it all into state court that doesn't have those judges typically don't see these cases as much. They don't have that level of institutional knowledge to be able to handle those. And of course, the standard itself is going to be much lower, and I think much more difficult for employers to achieve dismissals and summary judgment in those types of cases.
Thank you, Mike. Phil, where do you see opportunity for alignment between the NCLA and the Pipefitters in this legislative session?
No, thank you for the question. I think there's a lot, workforce development and environmental policy. I think this is a really top of the list for us, and I think making sure these things are done expeditiously on the workforce development side, doing whatever we can do to collaborate and make sure that when we build something, we have training opportunities attached to those projects. I think that benefits both businesses and labor. I think lots of opportunities and risks, like I said, in environmental policy. I think most of us in this room agree we have to address climate change. How we do that, how we protect businesses and jobs, and how we transition in a way that is fair and equitable for everyone in the community. I think that those are all issues that we can hopefully find some common ground to support, and come through this session in one piece and with our wits about us.
Okay, thank you. This is our last question, gentlemen, but it's going to be for both of you. The off-duty use of marijuana was stipulated in Amendment 64 as falling under the purview of employer discretion. Since the passage of Amendment 64, there have been annual attempts to weaken and restrict employer authority in that regard. We fully anticipate the issue to emerge yet again this session. Phil, are pipefitters engaged in that issue? And if so, what are your thoughts and position?
Thank you. Yeah, the marijuana thing is interesting. I mean, we're 8 years on now from implementation of recreational marijuana in Colorado, and look, I would say probably by the end of the decade, this might even be resolved federally. So, the last couple of years we have expressed, some concerns about some of the bills that have sought to weaken this. I think the challenge, though, ultimately is one of impairment on the job. It's not whether you use the product off the clock. And I think the tricky piece here is really one of science, and hopefully we can work together to collaborate on advancing new testing techniques that give a real-time assessment of someone's impairment, rather than having someone who completely off the clock may use the product legally and then be fired because a urine or blood test shows cannabinoids in their system. And I think that's where we've struggled as a union, is not wanting to see our members fired for something they're doing off the clock legally, just like alcohol, frankly. But unfortunately, the testing science right now is not advanced enough, in our opinion, to enable there to be a massive change in the policy. So the one thing I would add is, a lot of this has come under more recent negotiations on our collective bargaining agreements. Like, what happens if somebody, has a random result but was showing no signs of impairment or didn't have a workplace injury? These are all things that, are subject to some of the bargaining we do with our employers over these matters.
Thank you. Mike, your thoughts on the importance of employer authority?
Oh, well, totally agree with everything you said, Phil. And I think that it's interesting to note that kind of how we got here is that we started years before even the recreational marijuana legalization. We had the medical marijuana legalization in the state, which, if you go back and look at sort of the legislative background for that, I think it was at that time it was only ever viewed as really for folks that were very sick and were not going to be in the workplace. And so that sort of evolved to kind of where we are now. And as the state that kind of led the way as far as recreational marijuana legalization, what you've seen with later passages of legalization of marijuana is those states have had the opportunity and have taken the opportunity to institute workplace protections, at least for non-impairment situations, for legal off-duty use. And we just haven't gotten there yet, which actually kind of surprises some of my colleagues that are constantly calling me and giving me the business about our laws here. We don't have those protections, and the Supreme Court actually dealt with that. There is a lawful off-duty conduct protection statute in the state, but when the Colorado Supreme Court addressed that issue last, it determined that marijuana usage was not covered under that because it was still technically a federal offense. So I think last session, I know there was a bill that was introduced that would have changed that would have instituted protections for lawful off-duty use. I anticipate that's going to come back, and I anticipate that's going to pass. And that frankly, I don't think from my clients' perspectives in a non-impairment situation is going to present a lot of issues. I think most of my clients, especially given the tight labor market now, don't even test in the pre-employment context and only in the impairment context. So that's what I kind of see the future on that front.
Thank you, Mike. Thank you both for joining us today in the labor discussion. Phil and Mike, we wish you the best. And if there's anything NCLA can do to help work with you, please let us know.